So data protection in healthcare databases, it's a big issue, because if we look at the projects that we handle for clients, we do notice that data protection is probably the biggest hurdle in such access models. There's obviously always IP. That's an important one too, but something has to finance the creation of the data, the making available of the data, etc. But usually that you can contract around. You can't contract around data protection, or very limited. It's statutory, it's in the law, and the law says what is allowed and what is not. And that law, you know the law, it's the GDPR mainly, but not only. It's also member state laws, very much so. Because the GDPR allows member states to deviate in relation to health data and genetic data, for example. It explicitly says so, that member states can adopt more restrictive rules, and they do so. So you always have to look at the GDPR and national law. You also have a very important one, it's sometimes forgotten, is the medical confidentiality obligation. That has nothing to do with the GDPR or data protection per se. It's the general privacy consideration, the obligation of a physician to keep medical data confidential. That's not harmonized in the EU. For example, in the UK, that's a common law thing. In Germany, it's a criminal law thing. So it's not harmonized, it applies in different ways, but it can actually complicate matters very much. Now, in relation to GDPR, GDPR defines data relating to health and genetic data, and it categorizes those data as special data, meaning that the processing of that data is restricted. You basically can only process it and share it if there is a derogation in the GDPR that allows for it. And for that derogation, you have to look at Article 9 of the GDPR. What you will notice there is that those derogations are very restrictive. And when it comes to scientific research, you basically only have two options. It's either consent or a member state, EU or member state law that allows for it, and specifically allows for it, and contains the necessary safeguards, that law. So it's not just any law. In relation to consent, there's the obvious discussion about how broad that consent can be. Recital 33 is famous or notorious, depending how you look at it. But it says that if for scientific research, a consent can be broader than a normal consent. A normal consent has to be very precise, so that people know precisely what they consent to. For research, the GDPR said, well, we can live with a broader consent because you can't always anticipate exactly what you're going to do in research. Still, regulators interpret it very restrictively. I've been working on a project for pharmaceutical industry where regulators actually asked not to use the term broad consent, because they don't like the term. You have to use something else. So that's the GDPR at a very high level. It's a complicated situation, in particular because Article 9 is so restrictive. So in relation to health data. What you have is, if you have data that has been compiled for healthcare and you want to use that for scientific research, you're basically in the situation of what we call secondary use or further use. That goes back to the general principle and a very important principle in the data protection law of purpose limitation. If you collect data for a particular purpose, you can only use it for that purpose. So if you collect it for healthcare, you can only use it for healthcare. You can't just use it only for something else, like research. So the research that you do on healthcare data is what we call a further use or a secondary use. The problem with that is that the GDPR regime is very unclear for secondary use. At first sight, it's very liberal, because it says in Article 5(1)(b) that scientific research is by default compatible with the primary use, as if it's not a secondary use. It is a secondary use, but given that it's compatible with the primary use, it's as if it's encompassed in the primary use. So you don't need a new legal basis. You don't need a new consent, because it's compatible with the healthcare purpose. What is very controversial, and the scope of Article 5 is very controversial. There's much discussion about how this is applied, what the scope of a broad consent is, if you have one. The European Data Protection Board is working on guidelines on scientific research as we speak. It's not clear yet what the timing is. It's going fairly slow. We hope by the end of the year, but we doubt it. it's a very difficult topic. Maybe this is also a good opportunity. I'll come back to it later. Anonymization, that also often comes up in these collaborations or these access models to healthcare data, because obviously GDPR applies to personal data, doesn't apply to anonymous data. So if the data is anonymized, it's free to go. Only the definition of personal data is very broad, is interpreted very broadly by the court. It includes obviously pseudonymous data. I say obviously because it's not obvious for everyone. We often still see people arguing that key-coded clinical trial data, for example, is not personal data. That's not how regulators, and frankly, the GDPR seem to look at it. There's a bit of discussion about that, who and when, but usually data that are pseudonymized, so where the identifying data is replaced by a code, is still considered personal data. There's no horizontal anonymization standard. Actually, data protection authorities generally resist that because they say it's very context specific, and to some extent they're right. Whether data is anonymous very much depends on the context in which that data has been collected, what the data includes, and how it will be used. So it's difficult to make a very horizontal standard that applies in all contexts. But there's also not a really very good sectoral standard either. There's different standards, different approaches. For example, you have the policy 70 for clinical trial data from the EMA, and that allows for the publication of clinical trial data. But we see regulators applying very strict interpretation of the concept of anonymization, very strict, making it really hard to anonymize data, in particular if you want to keep line data, so data on an individual level, in contrast to statistical or aggregated data. Then it really becomes very hard to anonymize data. European Data Protection Board is also working on new guidelines on anonymization. And we have guidelines, old ones, I think from 2012 or something. They're working on new guidelines. Again, the timing is unclear. It's pretty slow too. We're a bit concerned that they will be as strict as the old guidelines, which will make it very hard to anonymize data, especially in a health context where the data are quite detailed. And again, where you would like to have line data per individual, and that makes it hard to anonymize. So many problems in projects like that, a very often overly restrictive interpretations of the GDPR, a lack of a clear legal framework, much uncertainty, which in this sector and considering the nature of the data often leads to a fairly conservative approach, which is understandable because it is health data. Fines can be very important. So people tend to be quite conservative. Solutions. Well, we just heard about the EHDS. That could be a solution for access to that data. I do have a comment on EHDS. I think there's one flaw in it from a data protection perspective. I mean, the basic assumption on the EHDS is that as a data user, you get access to anonymous data. That's kind of the default approach. But as I said, the definition of anonymization is so strict that, and if it stays as strict as it's today, but I expect that a lot of research projects and a lot of researchers will ask access to pseudonymized data, so personal data. That's possible under the EHDS. It clearly says so. But what it doesn't do, and it's something that I honestly don't understand. So as you've heard, the EHDS creates an obligation for data holders to share data. That's perfectly fine. What it doesn't do, it doesn't create a right for the data user to access the data. Because what it says is that as a data user, you have to have a legal basis under your national law to access data. And only then there's an obligation for the data holder to share. Now, the reality today is that that right to access pseudonymized health data under national law very often simply doesn't exist. It's not there, at least not in a harmonized way. That means if you go back to the example of the Luxembourg research that you want to do, but if you happen to be in a country that does have a good law for data users, like France, you could probably do that research because you have a right to access data. I can tell you, if you're in Belgium, that right doesn't exist. We don't have that law that allows you to access that data. Neither does the Netherlands. So it would be easier to do that research from France than from your own country. And that's something I don't understand in the EHDS. It creates a legal basis for the data holder to share, but it doesn't create a legal basis for the data user to access. That is left to the member states. I don't understand that, to be honest. I don't understand if you can harmonize the sharing, why you can't harmonize the access. Subject to all the conditions that are in the EHDS. Why do you leave that legal basis to the member states? That's something I don't understand. I often compare it to a candy shop. You create a fantastic candy shop with all the data that is available, but there's no front door for the data user, unless there's a member state law that allows you to access it. And again, that law isn't there in many member states. So the benefit of EHDS will be very different for researchers in one member state compared to another, simply because that national law isn't there. So why didn't you harmonize also the access to the data? That's something I don't understand. Another solution is codes of conduct. Actually, FBI has been working on a code of conduct for some time now, but in a very restricted, very limited area, clinical trials and pharmacovigilance. But what we have seen is that it's a very slow process. There's a lot of discussion. I think there's quite a bit of disagreement among member states or among regulatory authorities. So it's hard to make progress on that front. It's a very sensitive topic. So I think that's about the time that I have. If there are any questions, I can take them now, or I can take them after the next speaker.